Good afternoon, everyone. Thank you all for joining us today. My name is Michael Alston. I'm Senior VP at Dominion Enterprises, the parent company of Franchise Ventures. I've been in the franchise and business for sale space for more than 15 years, since we began acquiring the lead generation brands that you see listed as our sponsors on the lower right. We invited current and recent customers only to attend today's webinar. So first, I want to say thank you. We appreciate your business. Why customers only? Because some of the solutions to the problem we're discussing today are available only to our active customers. After a brief introduction to the topic and how it applies to our business, I'll introduce our special guest, Eric Troutman, partner at Squire Patton Boggs and a leading global expert on our topic today. We will conclude promptly in 45 minutes so that we'll have at least 15 minutes to answer as many questions as we can. First, why should we take an hour of your valuable time on such an unsettling topic? Many of our customers are risking their businesses and even their livelihoods every day. How are they risking their businesses? By carrying out daily activities in franchise development or business sales. By calling, texting, and emailing leads from lead sources who do not acquire proper consent. By ignoring or improperly responding to complaints about consumers or law firms. By using agents or brokers or third parties who do not have consent or are not in compliance. And finally, by passing on leads to third parties or affiliates who call or text without consent. Here in a nutshell are the kinds of telecom regulations that people in our business are subject to. The compliance for each channel required ranges from simple rules for email to more complicated rules for the TCPA regulations, including a properly worded and legally vetted express consent. The difficulty to achieve ranges from fairly easy for email to the most onerous rules, and with technology evolving and courts making decisions, it makes it very difficult to stay abreast and stay compliant. Finally, the risk ranges from fairly low for email violations to quite high for the TCPA. So the question on all our minds today is, are we compliant? Before going any further, we want you to know that all of our companies acquire consent for our clients to email, text, and call. Here is an example of express consent that we require for any lead to be sent to our customers. This consent allows our clients to email, text, and call legally. Here's a high-level overview of our process. In fact, there are at least 7 steps that we take on every lead. First, we validate phone numbers and emails with leading third-party reference data. Second, we acquire consent that's properly worded, and we record the date and time when it was acquired. We check and remove known litigants using proprietary sources. We send leads that pass all of these checks on to our customers. And finally, we honor remove requests by prospects, inform our clients, and credit them for the leads. All active clients now have access to evidence of lead data validation and consent acquired. We will provide information in the follow-up to this webinar about how you can gain access if you've not already signed up. Each of us as business owners or employees who regularly reach out to prospects by phone or text need to know the answers to 3 important questions. Number 1, which of your lead sources acquires proper consent for you to email, text, and call? You can simply go to the lead forms of your suppliers and see with your own eyes. Question number 2, does your own website and do all the landing pages coming from Google or Facebook or any other sources gain proper consent for you to email, text, and call? And do you check the DNC list for the reappearance of numbers at the required intervals? Third, are you exposing your brand to additional risk by sharing leads with third parties to whom prospects have not given directly their consent? What is the risk of noncompliance? This is a list of the top 20 TCPA settlements in the last 3 or 4 years. Note that you see many household names here, from JP Morgan to Dish Network. All of these companies have teams of competent lawyers and experts to defend them. Eric, our speaker today, represented a number of these companies. You can easily estimate your potential exposure. To calculate class action exposure, you can multiply $1,500 times the number of prospects that you've called or texted since 2015 in the last 4 years. Example, if you've only reached out to 1,000 prospects, your potential exposure might be $1 million to $2 million plus legal fees. If you've called or texted 10,000 in the last 4 years, it might be more than 10 million plus fees. Our company supplies more than 10,000 leads a year to many of our customers. So the exposure can be quite large. But the good news is all of this can be avoided with simple adherence to the TCPA regulations and acquisition of consent, properly worded consent. I'm delighted to introduce to you our subject matter expert today. Eric is known as the czar of the TCPA world among companies like ours who seek to understand best practices and keep up with the ever-changing law. Eric also runs the site TCPAworld.com, which explains what is going on in plain English as opposed to legal jargon, so that business people like us, can stay abreast. Now let me introduce to you Eric Troutman.
Hi, everybody. I just showed up out of nowhere. You're going to enjoy this because not only are we going to give you a bunch of information right now at a very high level, there's going to be a really cool jump cut where I'm going to change clothes in the middle of this. It's going to be incredible. Pay very close attention. See if you can notice when that happens. Okay, so Michael, thank you so much for the introduction. The TCPA, folks, the Telephone Consumer Protection Act, is the biggest litigation cash cow of all time. It is a huge deal. It has made more millionaire plaintiffs' lawyers than any other statute in American history. In fact, it's getting very close to have made more millionaire plaintiffs' attorneys than all other federal statutes combined. It is an amazing, terrible, incredible piece of law that you have to know about. It can be utilized to deliver billions of potential exposure for day-to-day activity, as Michael was saying, that you might not even really give a second thought to, but that is a highly, highly regulated area of the law. We're going to talk through exactly what the statute covers, but at a very high level, we're talking about up to $1,500 for every single call you make if you're not complying with the law. There is a 4-year statute of limitations. That means calls that you made back in 2016 you can get sued for today, and that means calls that you make today you could get sued for until 2024. We could be looking at another president before you even get sued on calls that you're making today. And all of those phone calls during that 4-year period can get added up in a single class action. So billions of dollars can be at stake, and there are vague provisions in the statute. It is very difficult to figure out exactly what the law is at any given time. And that, as you heard Michael say, is why we created TCPAworld.com, where we break down every single development in the TCPA world every single day so that you can try to keep up. It's a great resource, and as Michael said, we may make it very easy to understand. We don't have a bunch of legalese around it. But let's go to the next slide. Let's talk about what the TCPA is at a high level. As complicated as the statute is, it actually is somewhat simple as well. If we can get the next slide, we can look, there we go. The restrictions are seemingly pretty straightforward, but there's a bunch of little tricks in here, a ton of them, and let's walk through them. All right, so first bullet here. We know that you shall not, thou shalt not, it's like the 11th commandment that you never read about. The 11th commandment, thou shalt not call or text a cell phone using an ATDS, we're going to get to that, without the express consent of the called party. Okay, so a bunch of kind of technical words there. You can't call or text a cell phone using an ATDS, whatever that is, we'll talk about it, without the express consent, I wonder what that means, of the called party. Who's the called party? We're going to answer all of that. Second, thou shalt not play a pre-recorded voice message. A pre-recorded voice message of any kind to a cell phone or to a landline, right? ATDS calls only to cell phones. Pre-recorded voice messages apply to cell phones and to landlines without the express consent of the called party. There's that language again, express consent, called party. We're going to talk about that. But first, pre-recorded calls, remember, separate from ATDS. They don't have to be an ATDS. Any pre-recorded call is going to trigger the statute. And pre-recorded calls, as we'll talk about in a second, they're interpreted very broadly. Any avatar, any soundboard, any ringless voicemail, any pre-recorded voicemail, all of those are going to qualify as pre-recorded calls that trigger the TCPA. Express consent, right? We're going to talk about that on a separate slide, but express consent can sometimes be very easy to obtain, and sometimes it can be very difficult to obtain. In the marketing context, which is the context you care most about right now, you have to have that consent in writing. It has to be conspicuously disclosed. It has to have very specific components to it that we're going to talk about here in a bit, and it has to be signed, separately signed by the individual who you are calling. Now, who you are trying to call, who you are actually calling. We'll talk about that in a second. Okay, next slide. Okay, so those are the high-level requirements. Pretty simple, right? Seems pretty straightforward. You have to have consent, essentially, to call somebody. We'll talk about why that's difficult. But here is what is critical. If you do not comply with the statute, if you do not take the statute seriously, if you think, oh, you know, who really cares? $500 to $1,500 per call, folks. You add all of that up, as Michael was saying, the numbers get humongous. We've got judgments out there right now against, not my clients, but against people who have violated the law, found to have violated the law. $256 million against a debt collector. $925 million against a company that was doing multi-level marketing. $2 billion against a company that was advertising a film using pre-recorded messages. These are massive, massive penalties. A number of bankruptcies of large companies have taken place as a result of the TCPA because they didn't take TCPA compliance seriously because, hey, it's a funny looking statute. No one really wants to pay too much attention to it, right? Well, you have to, and not just for your business. Personal liability. See those words right there on this slide? That should send a chill down your spine because, as you know, as owners and operators of businesses, 99% of the time, if your business does something wrong under the law, which I know obviously you try not to do, but if it does, the business is going to face the repercussions of that behavior. The business is going to have a judgment against it, and only normally under the law, under very rare circumstances, are the individuals that operate that business going to be liable. Here in the TCPA, it is very different. You have to understand this. In the TCPA, anybody who is involved with the TCPA violation, even if the violation was by the company, every single employee, including up to the CEO, including all compliance officers, including anybody who made a phone call or sent a text or sent a fax that violates the statute, is personally on the hook. That means not only does the business face millions or billions in potential exposure, but you, person who is watching my video right now, you might yourself have your personal fortune at risk, your bank accounts emptied, or your home put up for auction, as actually what happened to a guy out in Massachusetts once, based upon a judgment that was entered against him in Arkansas, a state he'd never even been to under the TCPA. It can happen to anyone who is involved with the company that violates the statute. The CEO of Porch, big company, they just almost went IPO last year, is facing a $56 million TCPA case right now that the court has refused to let him out of, and that the court has found that he can be personally liable for because he approved a business plan that included sending out messages that it turns out would have violated the TCPA, even though he didn't know that it was going to violate the law. That's the critical thing to keep in mind. Ignorance will not save you here. If the company violates the statute, you will be personally, potentially on the hook for that, even if you thought the conduct was completely legal. So you have to empower yourself. You have to have knowledge so that you can prevent the big mistakes that lead to liability in the first place. And that is what this is all about. This is the first step, not legal advice, but the first step toward making sure that you're educated. Now, I'm going to change clothes real quick. We'll be right back. So what is an ATDS? You'll remember I just told you the restrictions apply to two big classes of technology. One, pre-recorded voice messages, and secondly, an automated telephone dialing system, an ATDS. The TCPA contains a very, very specific definition of what an ATDS is because Congress, when it passed the statute, wanted the TCPA to only look at very narrow pieces of technology because we've got the big constitutional First Amendment doctrine here that says Congress shall not limit speech. The TCPA limits speech. When it was drafted, Congress intended it for it to be very narrow, but something dramatic has happened since 1991 when the TCPA was enacted, the robocall epidemic in this nation. And Congress has over and over again said that the TCPA is the crown jewel of the federal response to robocalls, and the FCC, which is the federal agency that interprets the TCPA, has agreed with Congress and said the TCPA is critical, and the courts have agreed with the FCC and said the TCPA is critical. So what these branches of government have done is since 1991, they've expanded the TCPA, and they've done it in patchwork fashion. They've done it retroactively at times so that today what you're doing is legal, but 2 years from now, the court will find that what you did was actually illegal based upon a new standard that they just created later on. That's what I'm telling you. The TCPA is an incredibly difficult area of law. It's incredibly complex. But right now, today, as we speak, I'm not going to give you the whole history of how we got here. There's not enough time. As we speak today, there's a massive split of authority. There are 3 circuit courts. The Fourth Circuit, the Second Circuit, the Ninth Circuit, and the Sixth Circuit. Okay, that's California, New York, and Ohio, and the areas around those regions. They all say if you are using any kind of a dialer that can dial from a list of numbers automatically, including probably your smartphone, okay, if it has the capacity to do it, even if you're not dialing automatically with the call that you're making, even if you're dialing manually, if the system that you are using has the capacity, even has the capacity to dial automatically, you are using an ATDS and you have to have the consent of the called party to call a cell phone, okay? There are 3 circuit courts, the 7th Circuit, the 11th Circuit, and the 3rd Circuit that say exactly the opposite. Can you imagine that? Exactly the opposite. You have to use a random or sequential number generator in order for the TCPA to apply to you. You literally have to be dialing randomly or the TCPA doesn't apply. So the same technology in 3 circuit courts of appeal and 3 big geographies in this country is going to be illegal. That same phone call using the same technology in places like Florida and Chicago, perfectly legal. Billions of dollars at stake, the same exact activity, 2 different places, and you're either completely up a creek or you're just fine. That's the TCPA, folks. The Supreme Court is going to be resolving this exact issue in a petition brought by Facebook, of all companies. It's going to be argued December 8th, and we're going to have a ruling from the U.S. Supreme Court deciding this issue. This is the 5th time the Supreme Court has ruled on the TCPA since 2012. It is the 2nd most reviewed statute in America by the Supreme Court, which again should tell you just how important this statute is and how fast this stuff moves. Next slide. All right, so I mentioned ATDS calls are one big class of calls that are covered by the TCPA. The second big class of calls is pre-recorded calls. Now with the ATDS, there's a big split, right? And maybe your calls and your text messages. Remember, a text is a call. So if you are sending mass blast text messages, just like if you're making a large volume of phone calls, that is going to trigger the TCPA. Okay, you have to have express consent, just like you need for phone calls, for text messages. Okay, pre-recorded calls are a different class. If you are using a pre-recorded voice message of any kind, you will automatically trigger the statute. So before we talked about the split, and the calls might be legal in one jurisdiction, it might be illegal in another jurisdiction. If you're using a pre-recorded voice message, that split doesn't matter. You are triggering the statute. That includes ringless voicemail. So many people ask me, Eric, can I use ringless voicemail in order to communicate with my customers? And I say, you sure can, as long as you have the express consent that is required under the law to leave that voicemail with a cell phone provider. And I know there's a lot of folks out there that'll tell you, well, ringless voicemail isn't an Article 3 or is an Article 3 information service. It's not an Article 2 telecommunication service. And you can say, that's true. And then you can also say, it doesn't matter because the case law has found that that distinction doesn't matter. Any pre-recorded voice message is going to trigger the TCPA. And there are some exemptions that apply when you're making a pre-recorded voice call that is non-marketing to a landline. See how tricky this stuff is. Those exemptions are currently being reviewed right now by the FCC based upon the TRACE Act that was just passed in 2019. Under Section 8 of that act, the FCC has to re-review previously existing exemptions. They're probably going to go away. So even the exemptions that exist today in these nuanced areas, these little nooks and crannies that you have to look for them, they're currently under review. Even if you find them, you can't even really trust them. What you need is consent. If you don't have it, it's a very dangerous world out there for you. And remember, the courts, again, like we talked about at the beginning, are expanding the TCPA. The courts just think the TCPA is the most important thing in the world. It's not. I mean, it's a bad statute, but the courts love it. They are applying the TCPA to things like please hold messages, your call may be recorded for quality assurance messages, right? Those little snippets that you play at the beginning of a live call. There are traps for the unwary everywhere here, folks. And when you're engaging in outreach, you have to be thinking about the TCPA and the implementing regulations with everything that you're doing. All right, next slide. Express consent. So we talked about neutralizing the risk of the TCPA, whether you're using an ATDS or a pre-recorded call. You can neutralize that risk if you have the right level of express consent from the right person. Now, let's jump to the identity of the called party, right? Well, you have to have the express consent of who? You might say, well, the express consent of the person you're trying to call, right? Wrong. It doesn't matter who you're trying to call. What matters is whose phone actually rings. Isn't that bizarre? If a customer gives you a wrong number, you are liable for calling that wrong number under the TCPA. So in order for you to be protected, in order for you to have an effective defense, you have to make sure that you are getting the right level of consent. We're going to talk about that, but that consent was actually provided by the consumer who you are trying to reach, so that it is their cell phone that rings. Isn't that insane? And it is strict liability for you calling a wrong number, for you calling a number that has changed hands, even though there is no comprehensive database yet available that will allow you to determine who owns what phone number. When that phone number changes hands or you call a wrong number, presto, you are liable. And the plaintiff's bar knows all about this, and they have made a huge industry out of filing what's called wrong number data class actions. When they use your data against you to demonstrate all the wrong number phone calls that your organization has made. It's a terrible thing that these folks do, and many times they're going to get away with it. We're going to talk about how to avoid that. But there are vendor solutions. I'm happy to say that Franchise Ventures has invested a lot in this particular area because they identify that this is a risk area. So we want to make sure that the calls that are being made are actually being made to the consumer that you're trying to reach. Again, there are databases that aren't perfect, unfortunately. Nothing's perfect out there, but they can get you pretty close. And they can also track when a consent is actually captured. You've probably heard of Jornaya or Trusted Form. The reason that these companies exist is to do that third-party verification that these consents actually took place. because when that consumer says, hey, look, I never accepted the disclosure, the video rendering will say otherwise. And that's really helpful in litigation. All right, one last thing to say about consent, actually two things. Again, we've talked about it, we're gonna say it again. Informational calls, right? You already have a relationship with this customer, you're calling them about a debt that's owed, you're calling them about something servicing related to advise them that a prescription is ready for pickup, right? Some sort of information. Very easy to get that consent. Very easy. If the consumer gave you the phone number in connection with a transaction and you're calling about that transaction, consent, it's given. You don't have to have anything else. That's all you have to have is just the phone number, just provided from the consumer. That's it. Don't skip trace, don't screen capture, just get the phone number from the consumer and you're fine. Marketing though, and marketing is very broadly defined in this context. Marketing requires the express written consent, again, conspicuously disclosed with a bunch of magic language. It actually has to say, consumer, you are agreeing to get marketing messages from me using an automated telephone dialing system or a pre-recorded voice message to a specific phone number from a specific seller for a specific purpose, separately signed and separately and conspicuously disclosed. Really high standard. Again, you've got to think about all of these issues as you're looking at whether or not you're purchasing leads. Who are you purchasing leads from? Are they following these rules? Do they have the third-party verification that you need to make sure that this is a valid lead? If you're using your own website to collect leads, cool, you have a lot more control, but that control is going to go to waste if you're not looking at your disclosures and making sure that these things are valid under the law. It's absolutely critical. And if they're not, big risk from a TCPA class action perspective. Last point on consent, it can be revoked. Oh joy. You go through all the hard work of getting the right consent from the right person, and like a bubble, it can burst. All they have to say is, don't call me anymore. And that will require you to stop using regulated technology to continue to contact that person. You can still pick up the phone and dial manually, but you can't use an ATDS and you can't use pre-recorded calls. And by the way, if you're making a marketing call to a number on the D&C list, even doing that, you can't even do that manually anymore because of the D&C rules. Next slide. All right, class litigation. We've talked about this a little bit. Extremely aggressive plaintiffs bar. They use discovery as a bludgeon to get you to settle the case. They're going to sue you. The first thing they're going to do is they're going to say, give me a list of every single phone call that you have made over the last 4 years and give me proof of every single consent that you've received over the last 4 years. This is what they do. If you've got good lawyers, they're going to push back. They're not going to produce any of that. But there are special rules at class certification that also enable the plaintiff's lawyers to succeed many times in these cases, even though they shouldn't. I've successfully defended over 200 of these, never lost a certification ruling. But a lot of people have lost certification rulings. And if you folks know what certification is all about, you know that if that case gets certified, you are going down the road to a very, very difficult path at trial and potentially millions or billions of dollars. The two biggest areas where you are at risk of class litigation, of certified class litigation, is lead lists, right? Where you're buying a list of leads and you're not paying attention where they're coming from, right? If you buy a list of leads and they are all uniformly lacking consent, that entire list could become the class list and you could really be in trouble. Similarly, if you don't have policies and procedures to make sure that you're complying with the law, the court might presume that you're not complying with the law and might be willing to certify a case for every call you've made because you didn't have the policies and procedures that would be necessary to prevent TCPA violations. And so the court is going to assume that you don't have the evidence you need to defend yourself in the case and certify it. Really, really, really high risk. Both of those activities, very high risk. Keep that in mind. Next slide. One last point here, and it's important as we start moving into what might be the Biden-Harris administration. The FCC, I know we've got a couple of trade organizations on the line of representatives, so pay attention to this piece in particular. The FCC has broad rulemaking and implementation authority when it comes to the TCPA. What that means is that the FCC can interpret the vague words in the TCPA. Remember, we talked about vague things like the ATDS definition, the identity of whose consent you need, what express consent really means. The FCC has the power to interpret all these vague provisions. There are currently right now 42 petitions to the FCC asking the commission to weigh in on various pieces of the statute and its regulations that are vague. And asking the commission, for instance, if somebody goes to a website and clicks the button to accept consent, but then says, it wasn't me, can the caller rely on that consent, yes or no, right? That question is not answered in the law. The courts sometimes say you can't rely even if you've got proof that somebody went on that website. If the consumer says it wasn't me, the courts are largely saying, well, take it to the jury, right? So you have to prove that consumer went onto your website that day. And how do you do that? It's pretty tough to do. But as an example, a petition to the FCC is pending right now to say, FCC, can you agree that everyone has the right to reasonably rely on a web form consent submission where we know that somebody gave consent? Just an example. Again, there are 42 examples like that where the FCC is being asked to weigh in. And remember, the TCPA was expanded back in 2003 from the very narrow way that Congress had drafted the statute to the very, very broad way that we've seen that 3 different circuit courts of appeal are now applying because of the FCC. The FCC, under the Wheeler administration, when President Obama was in office, took a very, very broad interpretation of the TCPA. That broad interpretation was binding on the courts. And so when the FCC did something just because it wanted to enhance its own power, right, its own ability to enforce the law, that enabled courts to read that same interpretation, and it allowed plaintiffs' lawyers to take advantage of what the FCC had done to broaden the law. Now, most of that got set aside recently in a case called ACA International by the DC Circuit Court of Appeal in March of 2018. That's great, except that now we've been left in this vacuum of uncertainty where the courts are trying to figure this out for itself. And as we've talked about, it's all split up. In the meantime, the FCC has issued another public notice that it intends to again interpret all of these vague phrases for the public. We've been waiting for that for over a year, and currently we've got Chairman Pai, who's a conservative and who is a big fan of TCPA reform, which is to say to limit the TCPA. He is currently the chairman. Guess what? His term ends in January, and he never got around, because they're very busy over there. He just never, the FCC never got around to doing anything to reform the TCPA and make the TCPA narrow again, which is what everybody really wants. Why not? Well, my firm and others do a lot of advocacy work to the commission. We talk to the commissioners and we talk to their staff, and they've said overwhelmingly, we need more participation from folks, especially trade organizations, but not always trade organizations, also companies coming in their own name, coming down to the commission, advocating before the FCC, talking to the commissioners and their staff to tell them, hey, look, this is what the TCPA is doing to us. We're small guys, right? We're franchise owners. We're just trying to communicate with our customers, and we're getting picked off in these big class actions because of the way the law is written, because the law is so vague. Unfortunately, while I know, again, I'm not trying to pick on anybody, but while the trade organizations and industry has been a little more quiet than they should have been when it comes to lobbying, one group has been extremely aggressive in lobbying the FCC, and that is, guess who? The plaintiffs' lawyers. And they've got this organization called the NCLC that basically does all their advocacy for them. And the NCLC is constantly in front of the FCC, constantly in front of Congress, arguing that the TCPA is extremely important and it needs to be broad. And these class actions are critical, because if these things didn't exist, we'd have more robocalls. And we all know that's not true. The bad robocalls that Americans hate come from scammers. They're IRS scam calls. They're all bogus and they come from offshore. The folks watching this, I know, are legitimate American businesses that are just trying to contact their consumers. And they've gotten painted with the same broad brush, though, as all these scammers, and the NCLC has a lot to do with it. The point is that Congress recently passed this thing called the Traced Act. Again, the Traced Act continued to emphasize the importance of the TCPA as the crown jewel of the federal response to robocalls. Rather than bring the TCPA back, rather than narrow the TCPA, the Traced Act makes it even more powerful and gives the FCC even more power to enforce the statute. You think $1,500 a call is bad in private litigation? If the FCC gets a hold of you, it's $26,000 per call. It's bizarre. It's just the nuttiest stuff. And right now, again, the current FCC under the Republican Chairman Pai has really not been picking on, the mom and pop shops, really not been picking on legitimate companies. They go after the scammers. They've done a pretty nice job, frankly, in their enforcement. Not perfect, but pretty nice, focusing just on the bad guys. As we move into the new administration, though, every indication is that there's going to be enhanced enforcement and that we can see a much more active agency. We don't know that, but that's certainly possible, certainly possible. So the requirements that you abide by the law are not just critical from a litigation standpoint, they're critical from a regulatory standpoint moving forward as well. Next slide. I guess that was that. Okay, super high level. Please understand, this is we went 1,000 miles an hour, and I could talk to you for 12 hours about the TCPA. Check out tcpaworld.com if you've got questions. We break down every single development, every single case, every single thing the FCC does every day, so that you can be abreast of the law. It's all free, no barriers. You don't have to sign up. tcpaworld.com. With that, Michael, I know you might have some questions here.
Awesome. Yes, we do actually have some questions. We're going to try to get to as many as we can here. I guess I'll start us off by just asking, we're getting a lot of questions about this. How do I ensure my lead form is compliant?
So there are 6 really kind of ticky-tack requirements that the lead form has to have. You should have a lawyer look at it, okay, like just to make sure. But let's just kind of tick them off real quick, okay? It has to identify specifically the phone number that is being called, okay? It has to identify specifically the seller of the product. It has to identify specifically who is going to be calling. Is it the seller or somebody else that's going to be calling? It has to state specifically that marketing or promotional material is going to be agreed to. Those words have to be in there. People always try to say, oh, do I have to say marketing? Do I have to say promotion? Yes, you do. It has to identify either pre-recorded calling or the use of an automatic telephone dialing system if you're going to use that technology. And last, it has to be signed. It has to be executed in some way under the e-Sign Act by the consumer who you are going to be calling. Of course, a signature, electronic signature, does work on a website as long as there's that little checkbox that the consumer has to check. It can also be obtained via text message. And again, all of this has to be separate. It can't be part of your privacy policy. It can't be part of your terms and conditions. It can't be buried in a larger document. It has to be its own separately signed disclosure that the consumer is acknowledging, I'm going to be getting marketing messages from you or somebody on your behalf to this phone number using an ATDS, using pre-recorded voice calls. You have to have all of that in there. Again, best to have a lawyer take a look at it. There's some cribbing, some shorthanding you can do, but by and large, you want to be cautious here.
Michael, this next question might be geared towards you. Does having the consent on the lead form impact conversion?
Yeah, Ryan, that's actually a great question. As you can imagine, having more text that has nothing to do with getting to the information you want, it does have an impact. It has a significant cost on our business, but the risk is high enough that we believe this is something we have to do, and that it would behoove our customers to do on their own websites. I see there's a question that's a really good point. I just want to get it out there before anyone jumps off, and that is the fact that many, and I'll let Eric comment on the percentage maybe, but most or many of these suits or complaints can be batted away at even no cost if you have the right consent and you know how to, address the person when the question comes up. Like if you either have legal advice or you know how to respond to them. So, in my experience, we have not had a client actually have a significant judgment in my awareness, but we have had some clients who have asked us questions because they've run into complaints. So, the purpose of this webinar is to kind of inoculate our clients, the folks on the webinar, from actually having a real problem by taking the steps in advance and knowing how to bat away these complaints. Eric, could you comment on that?
Yeah, so the TCPA is a very democratic sort of statute. And by that, I mean, it really runs the gambit in the sense that you can have these extremely huge class actions brought by just the elite plaintiffs lawyers in the country on the one hand, and you can also have them, brought by these, nobody pro per guys that will, shake you down for $500, right? And I see a lot of clients who, kind of had baked into their business model, the TCPA, so what? We get, a claim from this guy or that guy. You write him a check for $1,000, he goes away. And, if there's like a steady enough diet of those, people start to think that, well, that's all the statute is. And that's a huge mistake. Now, Michael, you're right. If you're obtaining the right levels of consent, when the big bad wolf does come knocking on the door, you're going to be able to get rid of that case very quickly. We get rid of these, the big class actions. If we've got the right consent, we've got the TRNIA, we've got the trusted forum, we can get rid of those very quickly. And of course, they help also with the little guy. But where you want to be careful, you just have to be careful, is you cannot allow yourself to believe that the TCPA is just this little small dollar statute and these little guys that knock on your door, that's all you're ever going to deal with. You just write them a check and they go away. That's true until it's not true at all. And when that day comes, you're going to really regret not having taken the statute seriously if that's where you're at.
Thanks, Eric. I see another question that's sort of related to how you go about this. Is there any difference for a business email or phone versus a personal email phone? So in other words, if the phone number is actually that of a business as opposed to a consumer, Eric, is there any difference?
Oh, so glad you asked that question. That should have been on the slide. No. In the DNC context, under the TSR, right, the telemarketing sales rules, there's all these exceptions that people think apply to the TCPA, but they don't. Under the TSR, for instance, or the DNC rules, if you're calling a business phone, you're fine. The rules don't apply to business phones. And if you're making a franchise pitch, that's not marketing, right, under the TSR. Under the TCPA, if you are calling a cell phone, it doesn't matter if it's a business cell phone or a residential cell phone, the TCPA applies. Huge trap, right? You think you know the law because you know the TSR rules and you think that applies to the TCPA. It doesn't. And there are businesses out there that are shams. They literally exist only to attract calls. They will list their cell phone on a website for a business, knowing that B2B companies are going to try to reach out, do a screen scrape, find that phone number and start calling it using an ATDS. And these sham businesses exist with these phone numbers specifically to get you to call them so that they will sue you under the TCPA. It is one of the oldest manufactured lawsuit schemes in the TCPA world, and courts let you get away with it. So if you are calling that business phone number, if you are texting that business phone number, and you're using an ATDS or you're using a pre-recorded call, voice, you have to have the express consent. Otherwise, it's the exact same rules. When you hear the Telephone Consumer Protection Act, you think, oh, it only applies to consumers. Now, the trick is the telephone consumer. Everybody that has a phone is the consumer of that phone. So the case law has found that everybody, every cell phone is protected under the TCPA, even if it's a business phone number.
So, oh my gosh, we have, I don't know, something like dozens and dozens of questions. So I'm going to try to combine them. There's a couple of business related questions. So do we have a list of compliant lead providers? So of course, we don't. We only know that the brands that sponsored this webinar, acquire consent, as we've discussed. But we wouldn't speak about any other lead providers. You can, if you want to just have a sense, if you go to their lead forms, see what's on them. That will tell you right away.
Yeah, you should talk to them. I mean, kick the tires. If you're vetting a lead source and you're not asking specifically about TCPA compliance, I mean, you are in harm's way. I cannot even tell you how much trouble you are in. My clients, I advise, if you're buying leads, have a checklist, right? And there's 15 or 16 questions where you're just going to rake these guys over the coal, and you want specific answers. Exactly what properties, what brands do you own? What websites are people coming to? What does the experience for that consumer look like? Do they know that they're going to be getting phone calls, or are you tricking them into thinking they're going to get something else, and then you just get their consent because they think they're going to get a quote, for instance, right there live on the website, when really they're just going to get a phone call from 3 or 4 people, right? You got to push those lead sources to make sure that they can validate not just that there's a disclosure, but that consumer experience is consistent with the disclosure, that they've got the third-party verification, Trinaya, Trusted Forum, or something else, right? And these guys in this business, they know, okay? Don't let them play dumb. They know about the TCPA, and if they're not talking to you about it, you've got to be talking to them about it.
So we have several questions about some of the information provided and how can I get more information, and what was that website you mentioned. So we will be sending out an email to all the registrar attendees to provide some more information and contact information. Of course, you're welcome to email me. My email's there on the last slide. We had another question. Do you guys, meaning us, I guess our companies, our brands, do you charge for leads who ask to remove themselves? And we do not. When we issue credits for anyone who asks to be removed. This is a question for Eric. Is it sufficient to explain your process in your privacy policy?
No, 100 times no. If you're making a marketing call, if you are, doing an informational call, I mean, look, privacy policies matter for a lot of reasons, right? They can help you, especially when it comes to data preservation, or you're going to sell, data or try to monetize your data. Cool, privacy policies, like you can get away with murder, right? But when it comes to the TCPA, again, conspicuous disclosure is required. Separately signed disclosures are required. You cannot just hyperlink a consent disclosure. You can't do it. You can get away with it. It's like, again, one of these special rules with the TCPA, right? You can get away with that for 99% of things, but you cannot get away with it when it comes to consent. That consent has to be front and center, has to be above the button. We haven't even talked about like the little ticky-tack, how to design your website, right? Has to be clear, has to be conspicuous, has to be above the button, like Michael showed you. He had a nice example, right? It's got the checkbox there. The consumer has to see it, know about it. Like there's no tricking, right? You can't trick the consumer into giving this consent. And the regulators and the courts are so aggressive. I cannot tell you how aggressive they are when it comes to websites. There was, I think, 9 different cases this year alone where TCPA defendants said, hey, look, we got the consent. And the court said, no, your website's too busy. The hyperlink wasn't clear. They checked the box and clicked the button, but the box was underneath the button. And so it was pre-checked, so maybe the consumer didn't see it. I mean, it's Looney Tunes out there. So you really have to take this stuff seriously. Go above and beyond. Assume that you're going to lose a little on conversion, probably, but realistically, a better informed consumer, right, a more transparent process is going to lead to a better conversion rate overall. So you're going to lose some folks that never click through your process, but at the end of the day, the people that do are the ones that actually are qualified and actually are interested in the products that you're pitching, right? So your conversion percentage overall should go up, even if the click-through process percentage goes down.
So Eric, I have a very technical question here. I think we can answer the when I match a candidate with models, I do territory checks before presenting. So does this constitute sharing with a third party without permission?
I think the question is about sharing the data, not making a call. Is that how you would interpret it?
Yeah, so look, data sharing is a little bit outside of the scope of this presentation. We've got experts here at Squire Patton Boggs that do that. As a general rule, again, you can get away with a lot with a well-worded privacy policy when it comes to data sharing, especially if it's aggregate data. And it sounds like this is an aggregate anonymized data review. So you're probably going to be just fine as long as your privacy policy says so. But this is pretty specific stuff. It's getting pretty close to legal advice. Give us a call if you have a question like that, and we can give you a better framed answer.
All right. Question, does sending group text messages fall under these restrictions?
That's a great question. So the law has not yet gotten to the new domain, right? There's some new frontiers, if you will. And the big new frontiers are push notifications. You talk, consumers or businesses are constantly looking for new channels of engagement. You're talking about IMs, of course, group text messaging on your phone, on your iPhone messages, and you start talking about, Facebook instant messaging, right? All of this stuff has only been whispered at so far by the regulators. No courts have addressed this stuff directly. But remember what I told you from the start. The courts and the FCC, every time there's a new engagement channel, they use the TCPA because it is the only statute on the books, folks, that regulates outreach to cell phones. It's the only statute. And the Congress has again and again said, we're not giving you a new statute. Just keep using this one. And so what the FCC and the courts have done over and over for decades is expand it and expand it and expand it to address new channels. So when we talk about things like push notifications, we talk about things like group texting that you just described, the short answer is there's no clear answer yet. But we know directionally, these are exactly the sorts of channels and efforts that the regulators and the courts look at. So what you have to ask yourself is, how are you using that group text? Are you using it to send a message to 3 or 4 people at a time? Or are you using it to send to 2,000 people at a time? If it's the former, you're probably going to be okay. If it's the latter, the courts are going to look at that and say, no, 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 no. You're just trying to trick us. You're just trying to do an end run around the ATDS text message blast component, and you're just trying to use a tricky way to get around it, and we're not going to let you get away with it. It's a little bit of common sense, but it's also a little bit of understanding that everybody listening to this that is doing outreach has crosshairs right on you, right? You are in a highly, highly regulated area, and the deck is stacked against you. You need good legal counsel, but you also need to be aggressive in your compliance and aggressively proactive in thinking through how might what I am doing right now look to a court that is hell-bent on stopping robocalls. And you are going to be right in the middle of that battle.
So Eric, here's one that's near and dear to my heart. Sarah asks, I'm on the D&C list and turn callers in regularly from spam calls, and they've never stopped. So how realistic is that this is going to come down to us? Is there a short answer to that one?
You mean how realistic is it that you are going to get sued?
In other words, all of us are turning in spammers, or using efforts to stop people from robocalling you. How realistic is it that there will be actually actions against us?
I mean, the short answer is it's high, right? I mean, I've got companies that are my clients that have made millions of phone calls a month for years and never gotten sued. I think, man, you guys live the most charmed life. And then I've got other clients of mine that open a call center, operate for a week, and face a class action. And they're equally compliant. I mean, to a degree, right, this is a crapshoot. To a degree, this is, it's just kind of luck of the draw. Now, there are things that you can do, as we've been talking through, to make sure that you are not kind of front and center on anybody's radar screen. You do not want to be on one of these message boards where people are talking about you as a scammer, and then you get onto somebody's radar list and they come after you. But the short answer is, do not think that, hey, everybody else is doing it, so I can't possibly get sued, right? We all know that you drive down that freeway, someone's going to get a ticket. The guy that gets a ticket isn't going to get to say, well, everybody else was driving the same speed. It's the same thing with the TCPA. And I cannot tell you, 4 years, folks, 4 years they can go back and get you. Okay, so just because you're not caught today or tomorrow or next year, it doesn't matter. 3 years from now, 4 years from now, you can get sued for everything you've done over the course of the last 4 years. And again, the pace of litigation is increasing. It's not decreasing. Now, I'm not going to tell you that you're definitely going to get sued, but realistically, it's more a chance that this is a question of when and not a question of if.
So Eric, we've got just like a minute and a half. Let's see if we can fit a couple more in there. How do we know if a lead supplier has all the necessary approvals and consents?
You got to ask. You got to kick those tires. You got to push them, and you got to make them prove it, right? Send me screenshots. Have very firm contract language with them that you are only purchasing consented leads. Make sure that they understand that you do not want them to buy leads to then sell to you from a third party. They have to generate their own leads. And if they're an aggregator, they need to tell you that. And if they use sub vendors, you need to ask who are these sub vendors and where are they getting their leads from? It's on you, right? This is caveat emptor, pal. I mean, it is buyer beware. And you have to do this for yourself because you cannot expect most lead providers, unlike good folks like Michael, most aren't going to open up and say, hey, look, this is what we do for you. We take care of you, right? Most, it's a dirty business out there. And they're going to try to sell their leads if they're consented or not. This is just the truth, right? So you have to protect yourself because they're not going to be looking out for you.
So quickly, what would be the liability for a franchise company if a franchisee is buying leads that are not coming from a third party that has proper consent?
It's a great question. Very gray area. For the most part, there's no special rules for franchisor relationships under the TCPA, so it's going to be the standard rules apply. However, courts look really carefully. They can think of cases like Papa John's, right? Franchise model, franchisee goes out, sends some text messages, Papa John's ends up on the hook. The corporate mothership ends up on the hook for the franchisee's behavior. It happens. Okay, if these franchisees are out there pitching your brand in a text message, you've got to understand the courts are going to look at that real careful to see if they can find any way that you knew about it or should have known about it or controlled it or encouraged it. And if they can find any of those, you're going to be on the hook.
And the last one, is an auto respond text message sent to an individual lead when a form is received, like an automatic text, considered an automated call text? I think that's an issue.
Yeah, short answer is going to be yes. There's good companies out there. I represent some of them that have really good kind of text communication as a good channel that goes along with the voice channel that actually increases engagement. Consumers like that, actually, so long as it's deployed with consent. You can't just deploy that without the right consent. But if you're using it as a contact channel following a lead, where the person is part of their experience is going on the website, submitting the lead, and then within a few moments or minutes receives a text message from that brand, that's a good engagement, so long as, of course, you've got something scrubbed to make sure you're not texting the wrong number.
So Eric, I guess the greatest compliment to your content today is there are at least 50 more questions we're not going to get to. So we'll try to put something together or respond to some of the in very specific individual ones. But Eric, I want to thank you again for your time today, which I know is very valuable. Thank Ryan for helping facilitate today, and thank everyone for joining us, spending an hour with us on this very important topic. Thank you so much.
Thanks, folks. Bye-bye.